Good morning and welcome to the Judicial Committee of the Privy Council. Today is the second day of an appeal from the Court of Appeal of the Eastern Caribbean Supreme Court in the case of Lau and Chu. One of the justices has been feeling unwell and doesn't wish to disrupt the hearing, but there may have to be a short adjournment and a temporary suspension of broadcasting if he feels unwell again, and I apologise for any inconvenience. Mr. Richard Hacker QC is currently making submissions on behalf of Mr. Chu. Mr. Hacker.
Lord, I'm obliged. We concluded yesterday with my submissions in relation to the Eshelby principle and the Roban-Jig variant of the Eshelby principle, and we submit that they continue to apply, that the Roban-Jig variant continues to apply in English law and must also continue to apply in the BVI, and that the Court of Appeal was correct to hold that it applied to these proceedings, which we submit were incurably bad at the date of their issue, because the appellant at that date had no basis for invoking the just and equitable jurisdiction of the court. My Lords, Your Ladyship, assuming that the principle does continue to apply, whether in its broader or narrower form, how is it to be applied in petition cases? Our submission on this is very conveniently encapsulated in a judgment of Mr. Justice Balmer, as he then was, in a case which is generally referred to as re Cammytown. It's tab 170, page 6803 of the bundle. And I'd just like to take you to a passage on which we rely, as it helpfully encapsulates the submission that we make to the board. If your lordships would go to page 6804, 6804, holdings 3 and 4. The matter to be tested by analogy was to the situation in actions begun by writ, in which an application was made to introduce post-writ material by way of amendment, whilst it might have been permissible to introduce such material where the effect was to clarify the basis on which it was said that a cause of action existed. And my Lord, I'll interject to say that was the basis on which the evidence was allowed in this case. It was not permissible to allege facts so as to introduce into the proceedings a cause of action that did not exist at the time the writ was issued. Adopting that approach, if the position was that there was, on the basis of the material presently pleaded, a viable claim for relief under 168A, then the additional allegations would strictly be unnecessary, in that they would add little or nothing to the claim that was being made. Conversely, justification for unfair and prejudicial conduct relief predicated on matters which took place after the presentation of the petition was tantamount to a situation in which what was being introduced by the amendment was, in effect, a cause of action that did not exist at the time of the petition. Therefore, it wasn't appropriate to permit the introduction of the post-petition events into the petition. If I could ask your lordships, my lady, to read paragraphs 33 to 44, they represent our case on the application of the principle in this case. That's at page 6811. So, my Lord, I should have made it clear at the beginning. These were unfair prejudice proceedings, and what it was sought to introduce was an application for a winding up order. So, Lords and Lady, that represents the way in which we submit the principle ought to be applied in a case such as this. And there is reference in the judgment of Mr. Justice Balmer to the decision in Re-Files Brothers, and we set out in our case at page 63. I'm sorry, we set out at paragraph 46 of our case, which is at page 5151, the relevant extract, the much quoted extract from the decision of Mr. Justice McGarry, as he then was, and it's at 5152, the relevant citation. If on the facts existing when the petition was presented, it was then just and equitable to wind up the company, but subsequently it has ceased to be so, I do not think a winding up order should be made. No doubt if there were cogent grounds for complaint at the time when the petition was presented, but they afterwards melted away, there may be consequences in relation to costs, but a winding up order under this head must be based on subsisting facts and not upon past history. Now that is relied upon as supporting the proposition that one can introduce post-petition matters. But, my lords, we submit that it states the basic proposition that the facts justifying a just and equitable winding up must exist at the commencement of the proceedings, but the court has to look to what happened afterwards to establish whether or not the justification continues at the time of the hearing. So as applicable to the circumstances of a deadlock case, we say that whilst you can bring in new material in order to establish that there wasn't a deadlock, you can't bring in the new material to establish that there was a deadlock back at the date of the presentation of the petition. In paragraphs 51 and 52 of our written case, we address two authorities relied upon by the appellant, Walter L. Jacob and Jenkinson Soupscap, a New Zealand case, and we have nothing to add to what we already say there. Neither of those two cases is authority for the proposition that a petitioner who cannot establish a case for a just and equitable winding up on the facts as they stood at the petition date can perfect their case by reliance on subsequent events. That is not what those cases were concerned with. We submit that the emphasis placed by the appellant and on the fact that in the BVI a winding up commences at the date of the order rather than the date of the application is a red herring. The date of commencement of the winding up is relevant to a number of matters, all of which are concerned with the collection and distribution of the assets of the company. The factual basis on which the order was made is wholly immaterial to those matters or to the administration of the statutory trust imposed by the winding up order. That's all I want to say on what we call the temporal limitation. The subject matter limitation is also an important issue. We deal with that in paragraphs 54 to 60 of our written case. It turns on the extent to which the judge was entitled to find that there was deadlock in OSL, and that's always what he's looking at, by reference to events occurring in Beibu Gulf, in which OSL was only a 49% shareholder, and the affairs of which it was neither able to direct or control. An example is the emphasis placed by the judge on the finding, which would be in any event challenge, that the respondent had given the appellant the runaround in relation to the provision of financial information concerning Beibu Gulf. We're going to come back to that. This was financial information to which the appellant may have been entitled as a director of Beibu Gulf, but it could not credibly be suggested that OSL, or even PBM as the member of Beibu Gulf, was entitled, for example, to ask questions concerning draft unaudited accounts of Beibu Gulf produced by KPMG, a copy of which was supplied to the appellant in his capacity as a director of Beibu Gulf. the finding nonetheless played a part in the judge's evaluation of whether a case of deadlock had been made out in relation to OSL. And this notwithstanding his finding that by the time of the trial, the appellant had actually received the Beibu Gulf audited 2013 and 2014 accounts, and that's paragraph 91 of his judgment. It's appropriate also to note that although the, quotes, withholding of information was said to have prevented the appellant from putting a price on his interest in PBM, and was thereby a cause of all the difficulties between the parties in relation to the arrangements to separate their business in 2014, we submit that this is demonstrably not the case, as we can see from an email sent by the appellant to Mr. Zhu of the PRC interests on the 6th of March 2015, in which he puts a price on that interest of $26 million. And the reference to that is 2372. So the significance to the deadlock issue of the withholding of alleged withholding of information at the Beibu Gulf level was, as we suggest, spurious. A particular area of concern to the Court of Appeal, and it's a matter mentioned a number of times in the Court of Appeal's judgment, and in fact, many of the analyses in the judgment lead back to this point. Particular area of concern was the very heavy reliance that the judge had placed on the issue of the recovery of the PBM funding from Beibu Gulf, which he described as the ultimate breaking point, and which the Court of Appeal rightly, we submit, regarded as an issue at the Beibu Gulf level and not the PBM level. We quite accept, to deal with a point I think made by the Lord Briggs yesterday, that if the appellant had wished PBM to take enforcement action to recover the money, a disagreement whether to do so would have been an issue at the PBM level, although we would add in parenthesis, if it was simply a difference of business judgment as to whether or not it was in PBM's interest to do so, that would not of itself have amounted.
All this discussion of the different levels, Mr. Hacker, I mean, of course, it's theoretically possible, isn't it, that the two individuals might not be able to agree on anything in relation to Beibu Gulf, but they might get on swimmingly when they're discussing the affairs of OSL.
Yes.
But on the other hand, they may have fallen out altogether and about everything. And if that be the case, then the evidence about Beibu Gulf is relevant. It's relevant anyway, isn't it, as a matter of fact, on establishing which of those positions is the case.
Well, my lord, it may be relevant to determining the state of their personal relationship, but where we take issue is with the proposition that it's relevant to establishing whether there is a state of deadlock in OSL. And the point I want to make, the point I'm about to come on to, is that to the extent there was any issue, and we suggest that actually in reality there wasn't an issue, it was agreed at the PBM level that the issue would be dealt with at the Beibu Gulf level. And at the end of the day, the appellant is invoking a jurisdiction of the court which depends on him being able to show that there is deadlock in a particular company. And he's either able to do that or he's not able to do that. To show that there are disagreements in other companies doesn't get him to where he needs to be. That's our submission. And that, if I may say so.
Lord Briggs.
Yes.
Mr. Lau and Mr. Chu's status as to in BB Gulf arose because of the 49% shareholding which OSL through its subsidiary PBL had in BB Gulf. And I know it's wrong to say they were there to represent OSL's interest, but it was on account of OSL's shareholding that they were there. Is it really sensible to say that their inability to cooperate with each other while both appointee directors of OSL stroke PBL, is wholly irrelevant as to whether there was a deadlock in OSL PBL.
Well, my lord, we suggest that there actually were no difficulties. I'm going to come on to the facts.
But leaving that aside, I'm just asking the question of principle. You're seeking to, as it were, kick into touch everything that happened at the BBG level, and in particular, everything that happened as between Mr. Lau and Mr. Chu at the BBG level, as if it's in principle irrelevant because it's the wrong level. So before addressing the question on the facts, it would help me if you'd address my question on the principle.
Of course, my lord, I understand. Well, our answer to that would be that as directors of Beibu Gulf, they owe duties to that company to act in its best interests.
Of course.
And those were owed quite independently of the basis on which they were appointed. So if they disagreed, for example, if there were a disagreement between the two of them as to whether or not it was in Beibu Gulf's interest to retain the monies for the purpose of potentially acquiring other ships rather than the ones which the money had originally been raised to purchase, that would be an issue in Beibu Gulf. It doesn't establish deadlock, and it doesn't matter the basis on which they are there as directors of Beibu Gulf. They owe duties to Beibu Gulf, which, as directors of Beibu Gulf, they owe duties to that company, which override, in a sense, it's not a very accurate way of putting it, the basis on which they were appointed to act as directors. And we refer in our case, I think, to Gwembe, a case called Gwembe, which establishes that.
One with which I'm very familiar.
Yeah, I'm sure your lordship is. So, my lord, we say that issues which arise at this different level may be reflective of differences about the way in which the business of that company should be managed, but they don't establish deadlock at the level of the company with which the court is actually concerned. I don't know if that's an answer to the question of principle, but as to the facts, I'm going to return to this when we get to the factual deadlock case. But to presage what I'm going to say, as the documents show, the respondent suggested to the appellant, so Mr. Chu suggested to Mr. Lau, in early 2014 that the question of repayment of the money was one best raised with the board of Beibu Gulf, in other words, with the joint venture partner, the PRC interests, and the appellant agreed that he would do that. And he thereby accepted that the question was one to be resolved at the Beibu Gulf level and not the PBN level. And that, we submit, was certainly the position at the date of the petition, and indeed thereafter. It was at that level that the issue needed to be dealt with, and was in fact successfully dealt with. And that's a different basis, a different issue on which we say that the judge erred fundamentally. But I'm going to come back to that. So we submit that on the facts of this case, whatever the question of principle, on the facts of this case, the Court of Appeal was plainly right to hold that any difference of opinion as to whether repayment should be made at the Beibu Gulf level could not give rise to deadlock at the OSL level when OSL was unable to control the decision-making in Beibu Gulf.
Could you just give us the documentary reference for the agreement on the part of Mr. Lau?
Yes, my lady, I will come to that when I go through the chronology, if that's acceptable. I don't have any tips at the moment. Thank you. As I was submitting, the Court of Appeal was plainly right to hold that any difference of opinion as to whether repayment should be made at the Beibu Gulf level couldn't give rise to deadlock at the OSL level. And this was one of the central planks of the reasoning of the Court of Appeal's decision. And we submit on its uncontested facts, and I'll come back to that reference in a moment, it was plainly unassailable. In paragraph 88 of his judgment, I don't need to ask you to turn this up, I think, at the moment, the judge relied on several authorities, including the English Court of Appeal decision in Rakind and Gross, to justify looking through the legal formalities and true corporate structure to the business realities. Rakind itself was a case where the corporate structure involved a wholly owned subsidiary. Of course, you can look through. We don't suggest that the judge was wrong to look at what was happening in PBM. That was wholly owned, controlled by OSL. And the Eastern Caribbean Court of Appeal in Union Zone, a case to which my learned friend took you yesterday, and we give the reference in paragraph 57 of our case, held that it was only permissible to look through the corporate structure where the entity in question was a true subsidiary, in other words, was controlled by the subject company. Although Union Zone was a decision of the Court of Appeal that was heavily relied upon by us, and it was directly binding on the judge, and directly relevant to the issue which he was addressing in paragraph 88, he doesn't mention it in the judgment. It follows, for the reasons that we've advanced in paragraph 58 of our written case, that the Court of Appeal was quite correct to hold that the judge was wrong to place reliance on any disagreements or inability to work together at the Beibu Gulf level, irrespective of the fact that the two gentlemen were appointed as nominees of BBM, in deciding that a case of deadlock was made out in relation to the affairs of OSL. And the nub of the Court of Appeal's judgment on this point is at paragraphs 56 and 57, and the reference to that is page 4374. So we conclude our submission on this topic by submitting that the Court of Appeal correctly held that the judge had taken into account irrelevant matters in reaching his decision on deadlock. And that takes me to our case on deadlock and the factual issues in relation to deadlock. That divides down into three topics. First of all, what our case on deadlock was before the Court of Appeal. Secondly, the facts and the judgments. And thirdly, whether if there was deadlock, the extent of the appellant's contribution, which we submit, is sufficient that it should disentitle him from being granted equitable relief. Our case on deadlock, which was advanced to the Court of Appeal and accepted by it, is set out in paragraph 73 of our written case. And I just invite your lordships to, milady, to remind yourselves of what that case was. It's at page 5161. So that represents the case which we advanced. We submit that it's an entirely logical series of propositions which lead in our submission to the conclusion on the facts that there was no deadlock in relation to the company which the judge was being asked to wind up. The appellant contends that we conceded deadlock at the trial and it wasn't open to us to resile from that concession on the hearing of the appeal. This submission is factually wrong, as no such concession was made, and we provide in paragraph 61 of our written case the bundle references which support that submission. Before I address the chronology of events which are described in paragraphs 74 to 114 of our written case, which rely heavily, but by no means exclusively, on the documentary evidence in the court record, I'd like to respond to two criticisms made by the appellant of the use to which we have put the documentary evidence, both before the Court of Appeal and the board. First, we're accused in the appellant's written reply submissions of impermissible island hopping. This criticism is, in our submission, equally is unfounded. We submit that a selective reference to the evidence is inevitable in the context of an appeal where there are stringent limits on the length of both the written and oral submissions. There are many thousands of documents, detailed affidavit evidence, and the transcripts of 4 days of oral evidence. As the judge observed in his judgment, he received many hundreds of pages of written submissions from each of the parties, and the written submissions of both parties inevitably then, as now, highlighted those aspects of the evidence which best support their case, that the appellant is as much guilty of having done this as we are. Secondly, it's suggested, and this is a recurring theme, that we are not entitled to rely on documents not put to the appellant in cross-examination. That submission must obviously be put in the context of the large volume of documentary evidence, which has to be set against the relatively limited time available to cross-examine the appellant, and the inevitable difficulties and delays occasioned by the fact that his evidence was given through an interpreter. The respondent's case was put to the appellant in cross-examination, even if it wasn't possible to put to him every document relied upon to support it. In addition, the judge's interventions discouraged the process of putting documents to the witnesses unless they related to some area of disagreement. And examples of that, simply for your note, are page 3761, lines 9 to 13, and 3805, line 7 to 3806, line 2. There was no issue as to the authenticity of the documents, and it's important that the board appreciates that the majority were produced by the appellant himself as exhibits to his own affidavit evidence, presumably because he considered them to be relevant to the issues. He had every opportunity in that evidence to identify any points to be made on the documents he was producing, such as, for example, that a board minute didn't reflect the discussion at the meeting, or that an email from the respondent didn't accurately reflect the true state of affairs when it was written. There is, we submit, no basis for criticising the respondent for not having put every document on which he now relies to the appellant in cross-examination, when the appellant had put them in evidence and hadn't, when doing so, challenged their accuracy or otherwise commented on or explained them. And we would also ask the board to note that various aspects of the analyses in the appellant's reply submissions, including which documents were and were not put to the appellant in cross-examination, are not accurate and need to be treated with caution. As an example, and I only give it as an example, I'm not going to run through the whole of the reply, and a not unimportant one, at paragraph 83, page 5209, states that the minutes of the board meeting of the 26th of November 2015, at which an important agreement was reached at the Beibu Gulf board level, to which the appellant was a party, regarding the repayment of shareholder funding, were referred to on the hearing of the appeal. So the complaint is we referred to this on the hearing of the appeal, but they weren't referred to at the trial. For your reference, starting at page 3730, are 5 pages of cross-examination regarding the meeting and the agreement reached at it. And the minutes of the meeting were indeed specifically put to the appellant at page 3730, line 12, and he was asked about them. So your lordships, my lady, can't take everything that's said in that reply as gospel. Of course, both sides have done the inevitable and picked the parts of the record which best support their own case. As will be clear from section F of our written case, we rely on the documents principally to establish the chronology of relevant events and submit that there is nothing in the appellant's reply to suggest that the documents to which we refer do not accurately record the events which they record, save as to one issue which I will save as to the question of an issue as to the accuracy of the minutes of the 15th of December BG board meeting, which the appellant at one stage challenged as being an accurate record. But to the extent there was an issue as to that, we submit that the judge found it in our favour on it by reference to his description of what was agreed at the meeting. In addition to the documents, the submissions on the events in our written case and our criticisms of the judge's findings in relation to them also include reference to the affidavit evidence of the appellant and to the oral evidence given by him under cross-examination, and I'll show you that in due course. And I remind you that in the judgment of Justice of Appeal Blenman, she states expressly that she also had regard to the witness evidence in addition to the documents when preparing her judgment. We submit that the chronology of events as described in section F of our written case paints a very clear picture of the way in which the dispute between the parties evolved, which differs markedly from the judge's description of its evolution, indeed so markedly that the Court of Appeal was entitled to reverse the judge's findings of fact. There is no real dispute as to what actually happened, or who said what to who, as almost every potentially relevant event was minuted or was the subject of discussion in email exchanges. This case is very different from Yenige, where the parties couldn't bring themselves to speak to one another other than through an intermediary. Here, the parties carried on a vigorous dialogue long past the petition date, and in circumstances where communication would have long ceased if this had been a true Yenige situation. Our broader criticisms of the judge's findings in relation to deadlock are identified in paragraph 75 and onwards of our written case. And can I ask your lordships, my lady, to just remind yourselves of what we say in paragraphs 75 to 83, which start at page 5163. I'm doing this really because we have limited time, and it's easier than my trying to summarize the point in different words. So 5163, paragraph 75 to 83. And I hope at paragraph 83, Lady Arden will find the reference that she was looking for, asking about earlier, which is the appellant's email of the 12th of March 2014, page 2103.
Yes, I spotted it. Thank you.
I'm obliged. So, my Lords, Your Ladyship, in those paragraphs, we have sought to explain why the judge's analysis of when and how a deadlock had arisen was simply unsustainable. It was, we submit, plainly wrong on the facts, and the Court of Appeal was fully entitled to hold that. Paragraphs 84 and 85, we address the judge's finding that the respondent consistently and repeatedly blocked the appellant's access to financial information regarding Beibu Gulf, which the judge held had contributed to the ongoing state of deadlock that he had found already existed very early on in the story. The important points on that are, one, that the finding was factually plainly wrong, as access to such information was offered, but not taken up on the basis of an entirely specious excuse. If you go to paragraphs 84 and 85, you'll see that although various suggestions were made as to how the appellant might clarify his issues with KPMG, the auditors, his explanation for not doing so was he didn't know who to contact at KPMG. Well, in the event, later on in the story, he had no difficulty at all writing to the head of audit at KPMG to raise issues with them. It was an entirely bogus excuse. At paragraph 89, I'm sorry, if Lordships are still looking at the earlier part. At paragraph 89, we make the
That
point.
said, though, sorry, just on the auditor's point, it's not really a proxy for getting information about the company from the company, because the auditors wouldn't know future plans and that sort of thing. They would simply know what they'd looked at in the books. They wouldn't necessarily know what was not in the books.
My lady, this was specifically with reference to issues which the appellant had raised in relation to draft audited accounts which had been prepared by KPMG, on which a series of questions were posed on those accounts. Why had this been treated in a particular way? Why was that missing from that particular category, that particular heading in the accounts? So these were essentially accounting issues. So we submit that they were the right people to refer the appellant to in the context of that. At paragraph 89, we make the point that as at the end of 2014, so we're getting close now to when the petition was presented, OSL and PBM had not had to take any decisions beyond those taken on incorporation, and there was simply no scope for deadlock to have arisen in either company. As you've already seen, the question of repayment was one which the appellant had accepted needed to be raised at the Beibu Gulf level, so it had ceased to be an OSL PBM issue. Now, paragraphs 87 and 88 are of some importance. They reference discussions between the appellant and the PRC interests, which the respondent was not copied into, and of which there is no evidence he was aware. And the PRC interests wrote a letter to suggesting a series of alternatives by which the appellant might realise his investment in the company. And one suggested option that was put to the appellant was that he might sell his shares to the respondent. Well, one would think possibly an obvious solution from his perspective. Now, if I can show you the letter. The letter is at 2339. and this is obviously a considered proposition on the part of the PRC interest. It isn't one of the simple one of the sort of general run of emails that went to and fro. They have considered the issue and looked at the assets of the company and so on. And over on page 2341, they have come up with a number of alternatives for resolving the differences that then existed between the parties. And the first of those was that the parties should buy out the other party's interests, and so resulting in one party completely withdrawing. So that's one of three alternatives that were suggested to the appellant. And we make the point in footnote 27 in our case, that although the appellant's affirmation evidence, and the reference is there, page 232, paragraph 117, provide a carefully worded explanation as to why he didn't approach the respondent in relation to proposals 2 and 3. And this is obviously drafted by lawyers, so it's carefully considered. The explanation is entirely silent as to why he didn't approach the respondent in relation to a possible buyout. No explanation at all is offered for that. The respondent is accused of having blocked a sale by the appellant to the PRC interests, but this criticism is unfounded. As things unfolded, it became apparent that they weren't willing to buy out by only a 25% interest. They wanted the whole 49% interest or nothing. The respondent can't be criticised, we submit, for being unwilling to sell his own shares simply to facilitate a sale by the appellant of his shares, and to describe that unwillingness as blocking a sale, as the appellant does in his case, is in our submission a gross distortion of the reality of the situation. Notwithstanding his lengthy experience in the shipping industry, and there's plenty of evidence about that, the appellant led no evidence at all to show that he made any attempt to sell his stake in Beibu Gulf, other than to the PRC interests, between learning that a sale to them was not going to be possible and launching his petition. And to pick up a point made yesterday, given the right of transfer in the articles, we submit that the burden falls square on the appellant to show that the just and equitable jurisdiction is engaged by establishing that the right of transfer doesn't give him a means of exiting the, quotes, quasi-partnership on just terms. That is an essential element of his claim, and it was for him both to allege it and prove it. Now, on the paragraph 90 of our case, on the Court of Appeal's holding as to the temporal issue, in other words, a case of deadlock needed to have been established by the petition date, this was the end of the deadlock case. There simply was no deadlock. And that takes one to the format of the proceedings, the launching of the proceedings, their format, the steps taken when they were commenced, and the inference which we asked the board to draw regarding the ulterior purpose in commencing the proceedings, which we deal with at paragraphs 154 and 155 of our written case. That's 5187, which I mentioned briefly, I think in answer to a question from Lady Arden yesterday. So we rely on what we say in 154 and 155, but there are two other points which I want to make on the question of the bona fides of the appellant in launching the proceedings. In 154, 155, we refer to a failed attempt to secure leave to advertise the petition on the 1st of June 2015, and the references to that are 3225 to 3231, especially at 3231, lines 12 to 21. Now, the need to advertise was on the, we submit, bogus premise that this was also a creditor's petition. In the event, the claim as a creditor was never pursued. It was quietly dropped. It was never formally abandoned, but at the trial, nothing was heard about it. Now, having been told by the judge, having made a failed application to advertise the petition, and being told by the judge that that was not an order that the court was prepared to make, what does the appellant do? At 2451, and I'd ask you to turn that up, that hearing, to which I've given you the references, was on the 1st of June. At 2451, the appellant writes to the company's financiers, BNP Paribas, to tell them that a petition has been issued in relation to OSL. I'm not going to take you to the authorities which demonstrate that that is improper. I think the situation speaks for itself. It was obvious that the appellant had wanted to be able to publicise the existence of the petition. He'd been told that he wasn't allowed to do that, but he went ahead and did it anyway, in the face of a decision from the court that he shouldn't do it. He might have been able to explain it away if he hadn't actually raised the matter with the court, but having raised it and failed, we submit that this is strong evidence of the improper motives in relation to the presentation of the petition. This the letter that was written can have had no other purpose than to disrupt and interfere with the financing, and was, we submit, either a wrecking tactic or it was intended to gain some tactical advantage. And it leads one to the submission, we would say, that it was hardly a surprise that at the very delicate stage, when the support of the PLC interests was withdrawn, when they removed themselves from Beibu Gulf in December 15, January 16, when their support in the form of their guarantees of the financing was withdrawn, that the appellant, it's no surprise that the appellant would not have rushed to tell, that the respondent, Mr. Chu, would not have rushed to tell the appellant of the Lohas transaction. The result of telling him was entirely predictable based on his past behaviour, as to which, again, and I have to keep emphasising this, there can be no factual dispute. This is why we put our case on the basis of the documents. The documents record what happened. There's no issue but that Mr. Lau sent that letter. So we say that the decision not to tell Mr. Lau of the Lohas financing transaction is entirely explicable on the basis of what had gone before. And it has to be remembered also that a document described as a washout memorandum, which is at page 2092, reflected a preliminary agreement to agree, as we would categorise it, whereby, and I quote, you don't need to turn this up, with effect from January 01, 2014, Mr. Chu Kong will be fully responsible for the profit and loss arising from the 49% shares in Beibu Gulf, and Mr. Lau will no longer be involved in any way. That was what had been discussed and at least tentatively, although not to the stage of a binding agreement, been agreed in early 2014. Now, since that time, that was part of an arrangement under which it was intended that the parties would split their interests. The appellant would take the Pacific bulk side of the business. The respondent would be left with the Beibu Gulf side of the business. Now, what had happened in the interim was that the appellant had indeed taken over the Pacific bulk companies. He'd taken control of those companies on the basis that the arrangement to split their interests had been a concluded agreement. There'd been a concluded agreement in relation to that. So he had resorted to self-help to enforce the benefits of the alleged agreement. The transcript reference to that is 3812, line 25, 3813, line 2. Now, just to give you the few relevant lines, the question was, Mr. Lau, you took over the Pacific Bulk series of companies physically right now, right? That was our mutual agreement, was the answer. So indeed, in Hong Kong, the appellant goes even further and alleges that the respondent holds his interest in the Pacific Bulk companies on trust for the appellant. And if that is the case, surely the corollary must be true. That is, that the appellant actually holds his Beibu Gulf interest, his interest in OSL, on trust for the respondent. We deal with that in a short appendix to our written trial submissions. The reference is 3156 to 3159. So although the appellant presents himself as the aggrieved victim in this story, it is, we submit, in reality the respondent who is the victim, in that it's his interest in the Pacific Bulk companies which has been forcibly taken from him, with no consideration having been paid, which is part of the subject of the Hong Kong litigation, whilst the arrangements in the washout memorandum, whereby he was to take the Beibu Gulf business, are apparently to be wholly ignored in relation to the Beibu Gulf side of their interests. This, we submit, as an important consideration when looking at the Lohas transaction. A solution needed to be found to the withdrawal of the PRC guarantees in circumstances where, as I will show you, the appellant was unwilling to take steps to implement the agreed arrangement, which necessitated PBM putting up $18 million of the financing, or the financing being extended. So there was existing financing guaranteed by the PRC interests. The guarantees were withdrawn. That either needed to be extended or replaced, or PBM needed to make up the shortfall and put up $18 million. Now, the appellant wasn't willing to see the arrangement put into place with the $18 million being put up, so the financing needed to be extended. And it was left to the respondent to find a solution to that issue, which had been created, as we say, and we'll come on to, by the appellant's unwillingness, refusal, to see the arrangements which had been agreed before the PRC interests withdrew implemented. The Lohas transaction was an alternative to simply allowing the loans to go into default. That's all it was. And what the judge should have done, but never did, was to compare and contrast the two alternatives. Should the respondent have let the loans go into default, with consequences which the appellant himself described in a letter which I'm going to show you, or should the respondent have tried to find a solution? I'm not going to say anything more about the Lohas transaction than that, because it really is not, there is no great mystery about it, other than to point out that my learned friend, I'm sure inadvertently, gave a rather misleading impression about the respondent's evidence as to when the transaction was entered into. And the reference to this in yesterday's transcript is page 68, line 4. What he said was that in the respondent's cross-examination at trial, it was accepted by him that the transaction was entered into on the 28th of, his transcript says October, I'm sure it means December, and he gives a transcript reference to that, which is 3872, and actually that isn't quite right. What Mr. Chu was asked to confirm at the reference which was given is that it was dated the 28th of December. The relevant cross-examination is actually at 3882, line 6, going on to the next page, where my learned friend interrupts Mr. Chew's explanation, which is never completed. But the substance of his explanation was that the transaction replaced a bridging transaction, which was entered into in December, and that the transaction was actually backdated to the 28th of December. A lot of weight is put on the date, but actually there is an explanation, and it's offered in, as I say, at 3882, line 6. That's a digression from the chronology, but I want to come back to the chronology now. Having launched the petition and sought, I'm so sorry. The Lord is not unmuted, so I can't.
I think I am now.
Yes.
Thank you. I think you were seeking to say that one of the justifications for LOHAS is that by then, that's late to December or January, the time of the December board meetings,
yes,
the washout memo still represented the underlying commercial agreement between the parties, which you say left Mr. Liu really no more than a trustee of his interest in OSL for Mr. Chew.
If they represent
the right analysis by that date, because the board minutes speak and the correspondence speak, don't they, of the remaining two ships being split, or at any rate, both put into OSL for the joint benefit of both of them, rather than all for the benefit of Mr. Chew.
Yeah, my lord, yes. I expressed, I think, I hope I expressed the process as being conditional on there having been a binding agreement. Now, it's Mr. Lau's position that the washout memorandum reflected was part of a binding series of arrangements. But whether they were or were not is the subject of litigation in Hong Kong. But on his case, we say they weren't, but on his case, which is that they were, that's what he's seeking to establish in Hong Kong. On his case, it must follow, he's taken the Pacific Bulk business on the basis that he was entitled to it under the arrangements which had been discussed, but we say had never been properly agreed. So he's taken that side of the business. So by the logic of his position must be that we are the beneficiaries of the other side of the business. It's not what we're saying. I'm addressing it because I don't want this to be misrepresented in proceedings in Hong Kong. I have to be very careful what we say. We're submitting that this is the logical proposition of the case which Mr. Lau is advancing. He can't, in other words, he can't take half one side of the business and then say he's also entitled to 50% of the other side of the business. That can't be right. So I was going to come back to the chronology, and we've got the petition which has been launched. We've had a failed application for the appointment of provisional liquidators, as we submit for an ulterior purpose, in proceedings which make broad-ranging allegations of wrongdoing. It is to be expected that the personal relationship would become more strained as a direct result of the appellant's own actions. And indeed, the presentation of the petition was itself causative of an inevitable heightening of tensions between the parties. And one sees that from the inter-attorney correspondence, the usual correspondence which one expects to see once proceedings are commenced, which courts are generally so uninterested in, as they represent statements of people's position more than anything else. And that begins at 2455, and the point is taken at 256. Our BVI attorneys take the point there that on his case, the appellant no longer had any interest in the group. And none of these matters, the implications of starting the proceedings, are discussed by the judge in his judgment. But we submit that even then, even in this bizarre situation that one has a petition presented, but ongoing discussions between the parties, it didn't mean that the appellant and the respondent couldn't agree on important business matters, or that OSL and PBM were deadlocked, to the extent that any decisions had to be taken at their level. In large part, there were no such decisions, as the important practical decisions were all at the Beibu Gulf operating level. And at 91 in our written case, and the page reference to that is page 91, page 5168, we describe how, notwithstanding their personal differences, the appellant and the respondent were ad idem in voting in favour of a proposal that the shareholder funding should be repaid. Here, the critical point is that this was a Beibu Gulf management decision taken at the Beibu Gulf board level, which did not in any way involve either OSL or PBM. And this demonstrates the fallacy of two of the judge's key findings. First, that the loan repayment issue was the ultimate breaking point in relations between the parties. It wasn't. They were plainly able to agree on it. And two, that it led to deadlock in OSL or PBM. The loan repayment issue was, as the respondent had always contended and the appellant had accepted back in March 2014, a matter for the Beibu Gulf to decide on, although a decision how to secure repayment on the funding could have arisen as an issue in PBM if the Beibu Gulf board had refused to repay it. That situation never arose, and the potential for deadlock was therefore entirely hypothetical. We submit that the judge's findings and his reasoning are completely flawed. We then arrive in paragraph 92 at the key events at the end of 2015 and the start of 2016. And this round of events began with the appellant's email to the PRC interests, which he said in cross-examination was intended to create a threatening atmosphere. Which appears to have prompted the 15th to 16th December Beibu Gulf board meeting, at which the documents referred to in paragraphs 93 to 99 of our written case plainly show an agreement was reached to which PBM must have been a party. Now, if I can take you to 93. So the letter is referenced at in paragraph 92 of our case, page 5168, and the letter itself is at 3742. Basically, what the appellant was saying to the PRC interests is, we need to find a way of getting me out of this company, because I will be doing untold damage if the petition goes on to a hearing and there's a winding up. So this he submitted, he said in evidence, or he accepted in evidence, was intended to create a threatening atmosphere, to bring things to a head with the PRC interests. This led to the board meeting of Beibu Gulf on the 15th and the 16th of December, at which the, and I should say in that letter or email, what the appellant proposed was an arrangement under which he and the respondent would each get one of the two vessels. That led to a board meeting. So in other words, the PBM interest in Beibu Gulf would be resolved by a process by which the interest would be split 50-50. Now, of course, one has to view that in the context of the ongoing issue as to his seizure of the Pacific bulk interests and the implications of that for his entitlement to receive anything at all out of the Beibu Gulf business on his own case. So he proposed simply that effectively PBM be bypassed and that its interest be split 50-50 as between appellant and respondent. And that letter, email, led to the board meeting on the 15th and 16th of December, at which he, again, the appellant, proposed a division of the vessels as suggested in his email. And the reference to that is page 704, paragraph 3. Perhaps I should ask you to turn up. This is the minutes of the meeting, as it's an important meeting. We can go to 704, paragraph 3. So at the bottom of 704, paragraph 3, discusses the repayment of the shareholder loans, and then he puts again the proposal he put in his letter that the PRC interest should take their two ships, and that he and Mr. Chu should each have one of the two remaining vessels. Now that was very convenient from his perspective, because that would have left Mr. Chu with nothing if the issue as to whether or not the washout had been effective was resolved in his favour. So that was a significant issue from Mr. Chu's perspective. And at the end of a long discussion on the 15th of December, no agreement had yet been reached, and we see that on page 705. No consensus at the board meeting on the 15th of December. Now, at the resumed board meeting on the 16th of December, the minutes of which are at 7:06, you can see that the previous meeting finished at midnight. This is, again, a not unimportant point. The meeting on the next day commenced in a leisurely way, we would suggest, at 11 o'clock and lasted an hour to 12 o'clock. The appellant's proposal to split the PBM interest by giving each of he and Mr. Chu one of the ships wasn't accepted, but a variant was unanimously agreed that the PRC interest would purchase two of the vessel owning companies, and that PBM would purchase the other two. It was further agreed that the funding provided by PRC interests would be repaid. PBM funding would be used to repay the ship financiers, with any surplus being held on trust pending completion by PBM. Now, it was always Mr. Chu's position that it was likely to be that there would be a deficit rather than a surplus. So what we find agreed on the 16th of December is an arrangement to which Mr. Lau assented. It's clear from the minutes that PBM would receive two of the vessels, not his proposal that each of the two individuals would get one, but that PBM would get both. Now, we submit that that was an important, perhaps the most important decision that PBM was required to take in the course of its lifetime. And we submit in paragraph 94 of our written case that PBM was a necessary party to the agreement reached. Couldn't have come to this arrangement without PBM assenting to it. And although the appellant and respondent attended the meeting in their capacity as directors of Baby Gulf, as the only shareholders and directors of PBM, they were in a position to, and that they did also agree to the arrangements on its behalf on the basis of re geomatic. Indeed, as we say in paragraph 94 of our case, the appellant accepted in cross-examination that he, quotes, as representative of PBM, agreed to it. And that PBM would have the obligation to perform this resolution. And the reference to that is 3765. This is all set out in paragraph 94 of our case. And we submit that it's perfectly clear that in relation to the only issue of any concern to PBM, the appellant and the respondent were perfectly well able to represent its interests and reach a consensus with Bebu Gulf, including on the issue which had been of particular concern to the appellant, and which, according to the judge's finding at paragraph 39 of his judgment, was the cause of the mutual ultimate breaking point in relations between the parties, which was the treatment of the PBM loan. This consensus between the parties acting at the PBM level post-dated the commencement of the present proceedings by more than 6 months. The appellant approved the minutes of the meeting by signing them after the continuation of the meeting on the 16th of December. He accepts in cross-examination, this is paragraph 94 of our case, that the solution, quotes, was proposed by the shareholders' meeting and I support it. However, so he accepted in cross-examination that the minutes accurately reflected what was discussed at the meeting. However, earlier in the proceedings, he claimed that the minutes didn't accurately record what was discussed and that he signed them, although he says it was all subject to agreement on what would happen to the vessels. And he claims, and this tells one something about the quality of his evidence and his explanations for events which don't suit his narrative. He claimed earlier in the proceedings that the minutes don't fully record all that was discussed because, quotes, I was very tired after the long discussions held in the night before and also on the morning of 16th of December. And that's why I pointed out the fact that the meeting on the 16th of December was effectively at midday and only lasted an hour. The suggestion that he would have signed minutes which were materially inaccurate given the issues at stake, we suggest are demonstrate that he is willing to resort to justifications for his conduct, which are simply untenable and unsustainable.
Mr. Hacker.
Yes.
Is it proper for this court to be making judgments on the credibility and reliability of witnesses?
Well, my Lord, I'm not asking your Lordship to make any finding as to his credibility or reliability, indeed, because in the event he actually conceded the point in cross-examination. So I don't
know how it's going to assist the board to have these comments. We have the judge's views on the credibility and reliability of the two protagonists.
I think, my Lord, my submission is more directed to the motivation of the appellant in bringing these proceedings and the story which he's been telling, whether or not his evidence was or wasn't reliable is not really the point I'm addressing. It's more that he's willing to bend the narrative to suit the case he's advancing.
Thank you.
Lord, I don't know if that would be a convenient moment.
Yes, we'll take our in any event, scheduled mid-morning break at this moment and resume in 5 minutes' time.
Lord, I'm obliged.
Thank you very much.
Thank you.
Good morning. This is the Judicial Committee of the Privy Council continuing the hearing in the appeal of Lau and Chu, and Mr. Richard Hacker is continuing his submissions. Mr. Hacker.
Lord, I'm obliged. As made clear at paragraph 5 of the minute of a 14th of January board meeting, I don't need to ask you to turn this up. The reference is 729 to 730. The outstanding issue which required resolution at the PBM level was how it was going to raise the finance for the $18 million shortfall between the $36 million PBM funding which was repayable to it and the $54 million purchase price of the two vessel-owning companies which were earmarked for it. That issue was never resolved because the appellant had already returned to his original 11th of December 2015 proposal that the two ship-owning companies earmarked for PBM should be transferred one each to himself and the respondent, not to PBM. That's the appellant's email of the 12th of January 2016, 2565. Although this was what the appellant had always wanted, because it bypassed the whole issue of the division between of the interests of the two parties, it was not the agreement, and there's no dispute about that, that had been reached in December 2015, to which, as we submit, PBM had been a party, and it was not the transaction which the directors of Beibu Gulf had been authorised to implement in a 5th of January 2016 Beibu Gulf board resolution to which the appellant had assented. This is all, I'm now on paragraph 101 of our case, all this is set out there. In an email of the 14th of January 2585, the respondent indicated clearly that it was not what he considered to be the proper course in light of the arrangements agreed at the 15-16 December board meeting and what had been discussed at the subsequent board meetings at Beibu Gulf. And we submit, and this is the essence of our case, that if matters ever reached a situation of deadlock, it was as a result of the appellant's failure to cooperate in implementing that which had been agreed by him on PBM's behalf, and his insistence on reverting to his preferred alternative of a distribution of the vessel-owning companies that bypassed PBM. And we give a reference to that, we give a reference in a footnote in our case to where that's discussed in the submissions at the trial. We therefore, or perhaps more accurately, the central plank of our defence at the trial was that if matters ever did reach a state of deadlock, it was that failure. But the judge did not deal adequately or at all with this argument, as we explain in paragraphs 104 and 105 of our case. We there set out what it is that the judge found, and we submit that he failed adequately or at all to deal with this issue. We deal with the clean hands issue at paragraphs 106 and 107 of our written case. We don't accept the dictum in the speech of Lord Cross in Ebrahimi represents the decision that responsibility must be sole. It was a dictum, and it was not his speech was not one which represented the decision of the majority. The majority didn't specifically agree with the speech, and there's no mention of the issue in the speech of Lord Wilberforce. Nor was the issue a live one in the Court of Appeal decision in Paramount, on which the appellant relies, because in that case it had been found already that the petitioner was in fact solely responsible. The court wasn't called on to decide whether a lesser degree of culpability would or wouldn't suffice. But all this is of no more, we submit, than entirely academic interest, because it was conceded by my learned friend at trial that, quotes, if reliance is placed on a deadlock situation brought about by misconduct, it must be shown this state of affairs has not been caused exclusively or substantially by the person seeking to take advantage of it. And that concession is recorded in paragraph 16 of the judgment, page 6, and we are content that the board should proceed on the basis of it. There is certainly no reason why the appellant should now be permitted to resile from it. So the issue is, was the appellant's conduct a substantial cause of the of any deadlock which did occur? In paragraphs 108 to 113, pages 5174 to 5 of our case, we describe the downward path which the relationship took, as we say, caused by the difficulties arising from the appellant's continued unwillingness to see the December agreement implemented, and an ever-increasing resistance to see ordinary and mundane corporate decisions taken at the PBM level, for example, the execution of proxies to allow the appellant, it was always proposed by us that it was the appellant, to represent PBM at a series of Beibu Gulf EGMs. Our interpretation of the events of 2016 is set out in those paragraphs, and that's paragraphs 108 to 113, and we ask the board to review the documents to which we refer. I can't take you through them all today, but which we submit support the case advanced. The board also has, of course, the competing narrative set out by the appellant in his reply submissions, and I've already suggested that caution may be required in treating them as a wholly accurate statement of what happened. But all the events of 2016 have in any event to be seen against a backdrop that there was an as yet unresolved application pending for the winding up of OSL on the basis that a state of deadlock existed. It was in the appellant's interest to ensure as best he could that effective decisions were not taken, and much of the posturing which occurred in the correspondence exchanged in 2016 has to be read in that light. Again, we suggest that the commencement of the proceedings was itself a contributing factor to any deadlock which may have arisen during the course of 2016, which certainly, obviously, it's hypothesized couldn't have existed when the proceedings were commenced. Paragraph 114 of our case, we conclude the narrative several months before the trial with an occasion when the parties were able to agree that the appellant could represent PBM at the Bebu Gulf 2016 AGM, and he did so. By then, the trial was fast approaching, and there is no suggestion that any further decisions needed to be taken in OSL or PBM before the trial or the judge's decision to appoint liquidators. Finally, at paragraph 115 of our case, we address the events, we criticise the judge's failure to address the events of 2016 in his judgment. We criticise particularly his failure to attribute responsibility for any dysfunctionality which may have reached the level of deadlock in 2016 to the appellant, and that, as your lordships, my lady, will remember, is one of our Rule 25 points, if the board is against us on the question whether there was deadlock. In paragraph 116 to 119 of our case, we touch briefly on the non-pleaded issues, which only came into the proceedings very late in the day as a result of the decision by Justice Wallbank to allow the appellant to introduce non-pleaded allegations by way of evidence, only a matter of weeks before the trial. Much is made by the appellant and the judge of the respondent's failure to call third-party witnesses over whom he had no control and who would have been asked to take part in the trial of a dispute that didn't involve them. The allegations were complex and serious, but there was no proper opportunity to explore them. The trial had originally been set down for 5 days on the basis of the allegations as they were in the petition, in the winding up application. And the introduction of a whole raft of new allegations obviously left not enough time for some part of the issues to be explored. And the part of the issues that wasn't really explored properly were the new unpleaded issues. And this led the judge to draw inferences which didn't have the status of findings, but which clearly influenced his assessment of the merits of the application before him. And we mention in paragraphs 116 to 119 two examples of significant errors made by the judge, which cannot but have been material to the inferences which he drew. These matters related to events occurring at the Bebu Gulf level. That's all conceded, apart from the LOHAS issue, which did involve PBM. All these other issues did not in any way concern OSL or PBM. They also all obviously occurred post-petition. And we respectfully invite the board to uphold the decision of the Court of Appeal on the basis that the exercise of the judge's discretion was tainted by the views which he formed in relation to these issues and the adverse view which he formed of the respondent as a result. And that's another of our Rule 25 points. And at paragraphs 120 to 121, we set out closing submissions in relation to deadlock. And that leaves the very important issue of alternative remedies and the rather less important issue of costs. And just in terms of timing, with my Lord's leave, I, like my learned friend, am happy to stand on our written submissions in relation to costs. My Lord.
If I could, sorry, perhaps this is an appropriate point. If I could just ask for clarification as to what you are submitting, the test we have to apply is for whether there is a deadlock in this situation.
I suggested to your lordships, I think 5 or 6 different formulations which the appellant had proposed in their written case. I went through yesterday early on in my submissions the 4 or 5, 6 different ways that it was put, but it all comes back down to the same thing. The dictum of Justice of Appeal Ferrara in Union Zone, it's not a breakdown in personal relations, it's an inability of the company in relation to which the application to wind up is made to function at either the shareholder or board level.
And do you say that that test is applicable even if we were to uphold the judge in regarding this as a quasi-partnership situation?
I do, because that's the way the appellant has put its case. When one goes through the appellant's case, that is the basis on which it is said that deadlock existed, because I think it's from memory, paragraph 66 perhaps of their case, where they say that there is no material distinction between the two deadlock strands in a case such as this. That's their case. So I'm relying on the way that they have argued their case in their written case.
I mean, the judge was very clear that the only issue on the partnership analogy was the deadlock issue.
Yes.
The only other issue was alternative remedies, which you're coming on to.
Yes.
But he saw it as the issue as deadlock, and
Indeed.
deadlock as formulated in the case law.
Yes. What I'd call functional deadlock as a shorthand, inability to function as a company ought to function.
So would I be incorrect to be asking myself whether the test is whether there is a mutual breakdown of trust and confidence such that the company cannot properly operate?
Well, my lord, I don't want to talk in generalities, and I'm not very, if I may respectfully say so, not very interested in breaking new legal ground. I'm responding to the case which was put against us by the appellant, and that is that this is a case of functional deadlock. So your lordship, with great respect, need not trouble himself with that question, because it's not how the case has been put and not how the case has been argued. As my Lady Arden points out, it's not the basis ultimately of the judge's decision.
Thank you.
In relation to alternative remedies, we explain at paragraphs 132 to 133 of our case why it was open to the judge, having decided that there was a case of deadlock made out, to investigate the possibility of a solution other than the nuclear option of a winding up. It's a course which had been adopted in other reported cases. Paragraph 129, we refer to a decision of Mr. Justice Weinlott, which a petition was stood over to explore an extrajudicial alternative remedy. We don't. What we say is that the Court of Appeal was perfectly entitled to form the view that that was a course open to the judge, and that it was unreasonable of him not to have availed himself of the opportunity which that course presented. It was a course which had been advocated by us in our submissions to him, and he thought it was unhelpful and inappropriate, and we submit that the Court of Appeal was perfectly entitled to find that he was wrong to have reached that conclusion.
But didn't Judge go through alternative remedies in some detail? He cast aside the Hong Kong alternative, the offer of alternative, the unfair prejudice.
Yes.
These are all considerations of the alternative remedy.
Yes, they are.
But he did go through it. I just wondered if you were saying perhaps he made an error of law, because he said when it came to the choice unfair prejudice or winding up petition, that was a matter for Mr. Lau to choose, that is just the same principle, litigant entitled to choose his remedies. I just wondered if you thought that was consistent with section 173. 167.
Well, I'm sorry, I didn't hear the...
whether that was, whether you say that was consistent with section 167, subsection 3.
Well, my lady, he plainly had to investigate whether or not there were alternative remedies and whether or not the appellant was behaving unreasonably in not pursuing them. And we submit, and we submitted to the Court of Appeal, and the Court of Appeal accepted, that the findings which he had made, and I think they are essentially findings of fact, I have to accept that, the findings of fact were erroneous, because there were, I'm going to come on to each of the remedies separately.
All right.
But it was...
seems to think that the question was not for the court, possibly, but for Mr. Lau to decide. You'll come to.
Yes. Yes, I understand. If that's what the judge was saying, certainly he was wrong. The court obviously has to decide, as a matter of fact, as I've just submitted, whether the remedies are. It's a two-stage process, and I take my learned friend's point on burden of proof in relation to the first stage, whether or not it's the burden lies on us to suggest the alternative remedies. I question, but I can't refer your Lordship's milady to any authority. I question whether that's right in relation to the question whether or not it's reasonable for the appellant not to be pursuing those remedies, and whether or not actually the onus doesn't lie on him to justify why, if alternative remedies have been, the existence of alternative remedies has been established, whether the burden does not lie on him to show.
Must at least be an evidential burden switching.
Indeed. Now, as far as the particular alternatives are concerned, we deal with those in paragraphs 130 and following of our case, page 5180, and we start with the proposition which, in our submission, in the context of the modern practice, does raise questions and should leave alarm bells sounding, and why the appellant only ever sought a winding up order to the exclusion of any other relief, and that has never been explained. It's not for us to frame alternative claims which he might have brought. He needs no encouragement to bring further proceedings. But whether or not an unfair prejudice claim could be framed, a number of the potential alternative remedies wouldn't in any event have required intervention by the BVI court, as we explained below. And we address at 134 a sale of the appellant's shares as an alternative remedy, and this is the one which the Court of Appeal found was the alternative remedy. And this was in terms conceded as an alternative remedy in the proceedings, and the reference is in paragraph 134 over the page at 5182, when my learned friend said at the beginning of his opening at the trial, "I entirely accept that one alternative is an order that one buys the other out. Of course, I accept that's an option in the present case." In these circumstances, we submit, and the reference to that is 3478, lines 11 to 14. In these circumstances, the Court of Appeal in these circumstances, the Court of Appeal is not to be faulted for having identified a sale of the appellant's shares to the respondent as an available alternative remedy. That, in our submission, should be an end to the appellant's challenge to the Court of Appeal's decision on alternative remedy. At trial, the appellant contended that a buyout was not the appropriate remedy, which is far from being the same as contending that it was not an available remedy. Principally, it was argued, because of the difficulties of the BVI court ascertaining the purchase price for the appellant's shares. Well, as to that, we've already seen, I've shown you this morning, at page 2372, that the appellant, not 2 months before starting the proceedings, had indicated that he was willing to sell his shares for $26 million. So he put a price on his shares already. The Court of in paragraphs, the Court of Appeal judgment 71, 72, and 78. That's 4381 to pages 4382. The Court of Appeal addressed buyout as an alternative remedy. It determined the appellant's remedy was to sell his shares. It rightly concluded a buyout remedy was reasonably available to the appellant, and if the judge could have given appropriate directions as to how to deal with evaluation if that arose as an issue. And all the arguments now advanced by the appellant in opposition to that were advanced to the Court of Appeal and rejected by it. And the argument which is advanced in paragraphs 181 to 184 of the appellant's case appears to proceed on the basis the Court of Appeal erroneously made a buyout order when it had no power to do so under section 162, and this was the point my learned friend yesterday. And he was puzzled as to why I was relying on the Court of Appeal's order, the formal order drawn up after its decision, to demonstrate that it hadn't. Well, I think the words of the order themselves, I'm puzzled by his response, because the words of the order themselves, which reflect the order being made by the court, do not refer to a buyout. That what the Court of Appeal was saying was, this was not a deadlock case. If it had been a deadlock case, that would have been the proper remedy. Of course, the court would never be making a buyout order, or even purporting to make a buyout order in those circumstances. And there's no suggestion in the wording of the order that it made that that's what it intended to do. It may be, with respect to the Court of Appeal, that what it's saying is not felicitously expressed, but the intention of what is being said is perfectly clear.
But Mr. Hacker, is the underlying point that a petition brought under the court jurisdiction to make a buyout order nonetheless a problem for the Court of Appeal's analysis?
No.
Can you distinguish, for the purposes of my question, between a purely private agreed buyout order?
My Lord, I think the answer to that is that what the Court of Appeal is saying is that they picked the wrong procedure, and they could have gone for a buyout order.
But they could only have done, as I understand that, they could only have done that by bringing an unfair prejudice petition.
Absolutely that. I don't think the Court of Appeal is suggesting, that's why it's not trying to make an order. That wasn't, I'm not suggesting that was an order available to it in these proceedings, but then the Court of Appeal wasn't purporting to make the order in these proceedings. What it was saying was, if there was deadlock, even if there was deadlock, Mr. Lau had gone down the wrong route. There was a different remedy available to him, which was to seek a buyout order. So it doesn't matter that it wasn't available in these proceedings. Indeed, it's critical that it wasn't available in these proceedings. He'd had the opportunity to seek the remedies in the alternative, and he had elected deliberately, and in the face of a recognition by his leading counsel very, very early on in the proceedings that alternative remedy might be the right remedy, a concession by his leading counsel at the trial that it was an option in this case, he had, if I can put it this way, pig-headedly continued to pursue the sole option of a winding up, because that was, and the reason for that we submit is because that was the most destructive
Over the luncheon adjournment, would you get me the reference for that?
I think
sorry, not over the luncheon adjournment, over at some point, because you did say you would get it yesterday.
I'm so sorry, the reference to?
That statement by leading counsel.
Oh, it was the, it's here, it's in paragraph 134 of our case. Is this the, I entirely accept that one alternative is an order that one buys the other out. Of course, I accept that's an option in the present case. That's page 3478, lines 11 to 14.
I have it, thank you.
Now, the appellant, I'm going to have to hurry a little, but the appellant also contends a buyout order would have been inappropriate because the judge had found the respondent had failed to show that he had either the inclination to purchase the shares or the means to do so. We deal with that in paragraphs 139 and 140 as in relation to, as we do with the question of valuing the shares. Two other alternative remedies which we posited to the judge at the trial, one of which he dealt with, one of which he completely ignored. One is litigation, and we make our point on that in paragraphs 142 to 150, and we make the point that the judge appears to have accepted that litigation, direct litigation by the appellant was an available remedy, but that it wasn't unreasonable for him not to have gone down that route, because why would somebody be required to embark on expensive and complicated litigation? Well, the answer to that demonstrates itself from the fact that that is exactly what he did, notwithstanding, and we make this point in paragraph 147, notwithstanding that he'd succeeded in getting OSL wound up. Can I just take your lordships, my lady, to paragraph 147, page 5185. Judgment was delivered on the 16th of June, although winding up had been advanced at the trial as the only effective means of vindicating the appellant's rights. No sooner had judgment been delivered than he commenced proceedings in Hong Kong, Singapore and Panama against, amongst others, Beibu Gulf and its subsidiaries and Lohas, and there's a judgment of the Hong Kong court referencing those proceedings, which we refer to there. And the actions included a multiple derivative action brought by the appellant suing on behalf of himself and the shareholders in the company that he just wound up. Although we submit it, it's unclear on what juridical basis he considered himself entitled to bring a derivative action on behalf of the shareholders, having persuaded the court to wind the company up. And not only has the appellant willingly, quotes, embarked on speculative and expensive litigation in seeking a shareholder remedy, the thing that the judge found it was unreasonable to expect him to do, but the winding up of OSL has been shown to be no more than a vehicle through which he can initiate yet further litigation in the shape of the Hong Kong winding up petition brought by PBM against Beibu Gulf. Those proceedings are funded by the appellant, there's no issue about that, and were bizarrely, we submit, commenced by the liquidators immediately after the hearing of the appeal in this matter. We can only speculate because the hearing didn't go very well, and whilst the judgment of the Court of Appeal, now under appeal, was awaited. Although we've challenged the liquidators to explain the decision, why it was that, having done nothing for 2 years, they rushed to start the proceedings while the judgment of the Court of Appeal was awaited, we've never had an explanation. And we submit that apart from, in paragraph 149, that apart from the tactical benefit of not having to establish his locus to sue, in truth, the only consequence to the appellant of the winding up order is a detriment rather than the benefit, namely that he's had to pay thus far at least $2 million, and that's referred to earlier in our case, of liquidators' fees. And importantly, the liquidators haven't used any of their statutory powers. So it's not a case where there's been extensive use made of examination, private examination of potential witnesses. They've just launched in, and effectively, if somewhere in our case we give the reference to the Hong Kong petition, if you trouble to look at the petition, you can see that it's actually a rerun of the allegations made in these proceedings. So it's just taking the dispute down another level. And we submit that it should or have been clear to the judge the supposed disadvantage of the alternative litigation remedies identified by the respondent were not disadvantages at all in his eyes. They have been objectively viewed from those of any normal person, but they were in any event equally applicable in a winding up. So what has the winding up, the question we ask is, what has the winding up given to the appellant that he hasn't already taken for himself and isn't otherwise available to him? And we submit that in those circumstances, the finding in relation to litigation as an alternative remedy is simply perverse and against the weight of the evidence. And then I can deal shortly, but with the significant issue of share split, because this is an issue which may yet trouble the board in the context of a different appeal, which is currently pending to it. We submitted to the trial judge, and we have taken the point in the liquidation that a distribution of the parties' interests in Beibu Gulf would be an effective means of bringing the winding up to a halt. And that's something which we suggested to the judge as an alternative remedy, something that we, Mr. Chu, was willing to agree to before he made the winding up order. And the short fact is this, the argument against that is, well, PBM may have claims which are valuable claims, and the distribution of the shares in Beibu Gulf would not benefit Mr. Lau in relation to those claims. The simple answer is that there can be a distribution at both levels, as we mentioned in paragraph 151 of the case, paragraphs 151, 153. It's perfectly possible for OSL to distribute its interest. Well, first of all, perhaps the logical process, the logical order is that PBM distributes its interest in Beibu Gulf 50-50 to Mr. Chu and Mr. Lau, and OSL then distributes its interest in PBM likewise 50-50. So Mr. Lau is left with 50% of the value of Beibu Gulf and 50% of the value of PBM. And he, as a member of PBM by this stage, is in a position to bring derivative claims in relation to losses suffered.
But doesn't a split of OSL's shares in PBM simply transfer the deadlock down to PBM insofar as the management of any asset of PBM other than shares in BBG is concerned? This argument all proceeds on the assumption that you've lost on deadlock, otherwise one doesn't get to alternative remedies.
Of course, no, your lordship is right. The way we put it is that gives Mr. Lau a direct derivative claim.
Why should he need a direct one?
Well, because if there's something wrong with an indirect one, there isn't. He's perfectly happy to run it as a multiple derivative action. But if there were any issue about multiple derivative actions, it makes it simpler for him to bring his claims. But to the extent that there is wrongdoing alleged, which it is said has caused loss to PBM and the recovery for which is an asset of PBM, that's always there, whether or not there is a distribution of the Beibu Gulf interests. So in a sense, my lord is quite right that it's not necessary that there should be a distribution of the OSL interest in PBM, but if it makes it easier, there's no difficulty in such a distribution to bring Mr. Lau closer to the recoveries which he says PBM is entitled to make. It's not necessary.
Mr. Hacker, was the question of a share split raised in the hearing before the judge, other than in your written closing?
My lord, I think the answer to that is probably no, because if it were, if it had been, we probably would have referred to it. I'm going to look to Mr. Locke to nod or shake his head, as he is much more familiar the detail of what was and wasn't put. I think we have to proceed on the basis that it was put in our closing.
Thank you.
So this was not addressed. The judge was at great pains to point out that he had read all the written submissions in extensive detail. So even though it may have come late on in the day, it is completely ignored in his judgment.
No, but my point is simply that the practicality of such a share split wasn't explored either in with the witnesses or otherwise addressed by the applicant himself.
No.
No.
And we make the point finally in paragraph 153 that a share split wouldn't have required the intervention of liquidators. Indeed, their appointment has impeded such a solution, as our numerous attempts to persuade the liquidators to bring the winding up to a summary close by effecting such a distribution have fallen on deaf ears, and there are various challenges outstanding, yet more litigation, which the winding up has itself generated, to their decisions or failure to take a decision. My Lords, that's what I want to say on alternative remedies. The conclusion is 156, 157. It's another of our Rule 25 points. To the extent that the Court of Appeal can go on to consider alternatives other than a buyout, we suggest that those are available alternatives and that they are also a basis on which the Court of Appeal's order can be supported. The appeal on costs, I'm very happy. In fact, I would be delighted simply to stand on our written submissions. I think it comes down to the very simple proposition that the time to take points on costs is before judgment is delivered. Unusually, it's a different practice in the BVI. It is the standard, universal, well-recognised and well-known practice in the BVI to make the order which the Court of Appeal has made, and that there was an opportunity to ask it to make a different order, but that the appellant didn't avail himself of that opportunity. That's what it comes down to. Lords, unless I can assist.
Mr. Hacker, were you going to address paragraph 100 capital B of the judge's judgment, second sentence? I was only just asking whether you could help.
Of course, let me take a look. 100 B, second sentence. Remedy of last resort. I think that's. I'm so sorry. This is the point about choosing the remedy. Well, yes, of course, a litigant is entitled to choose the remedy which he pursues. But if the court finds that he's made the wrong choice, because the statute requires the court to investigate whether or not there is an alternative remedy and whether or not he's behaving unreasonably and not pursuing it, then he doesn't have the free. I think what the lady perhaps is getting at is the judgment suggests that the litigant has a free choice. In the particular and unusual circumstances of this statutory jurisdiction, he doesn't have such a choice. His choice is trammelled by the wording of the statute, and to the extent that the judge suggests otherwise, that is erroneous. And I think the judge must, I'm prepared to credit the judge with a sufficient understanding that he must have appreciated that, but to the extent that he's suggesting otherwise, that plainly is not the case.
Thank you. Thank you.
Lord Briggs.
One further question. Mr. Hacker, is what I might call a deadlock in relation to which blame is not being attributed a subheading of unfair prejudicial conduct by the other person who is involved in the deadlock?
I would certainly suggest that as a matter of general principle, a deadlock situation can constitute unfair prejudice. I'm not sure that one needs to attribute fault in order for it to rise to that level. That it's a state of, in a sense, unfair prejudice is a state of affairs. The company is being managed in a way which is unfairly prejudicial. And if that means decisions can't be arrived at.
But if the case is that because of the deadlock between the 50-50 shareholders, the company simply isn't being managed at all, is that conduct of the company's affairs in a manner which is unfairly prejudicial to some of its shareholders? If you know the authority on the point, I'd be grateful, because it does seem to me there's quite an important underlying issue here about the extent to which you can simply say at the end of an otherwise unsuccessful defence of a deadlock winding up petition, well, he should have brought an unfair prejudice petition.
Well, we didn't say it at the end. We said it at the beginning, because it's
whenever you say it. But once you've lost on whether otherwise there's a deadlock.
I just want to add that we do have some authority already in the written cases, because in Yiniji, the court is clear that the deadlock solution is a shortcut. It's cutting through any question of impropriety.
Yes.
If you go into unfair prejudice, you have to show unfairness. That's what I would suggest.
Yes.
And not just deadlock. And deadlock is a route adopted as a shortcut to take that sort of issue out of the issues the court has to consider. And so while I would accept that deadlock may amount to unfair prejudice, it isn't necessarily so.
Well, my lord, my lady, if we are to be allowed to go away and research the point, we will certainly inform you if our researches are productive of any learning.
If you were to be given 7 days to make that research, would that be sufficient?
Yes, I'm sure entirely so.
Well, I'm sure if you can have 7 days, and Mr. Jones can have 7 days following to respond to your submission.
My lord, I'm very much obliged. My lords, my lady, those are our submissions for the reasons which we advanced in our written case. The submissions I made to your lordships, my lady, today. We submit that the appeal should be dismissed. Mr.
Hacker, thank you very much. Mr. Locke, given that you're present here, I have formally to ask you whether you wish to follow. Your time is up.
No, I do not. And I just wish to express my utmost gratitude to appear before my lord and my lady.
Thank you, Mr. Locke. Mr. Jones.
First, to deal with a short point on quasi-partnership. My learned friend said that of the 3 categories of cases that might point to a quasi-partnership, we only advanced the first and not the second. This is not correct. The second category, and I don't need to take it to you, I'll just read it out because of the shortage of time. The second category is an agreement or understanding that all or some of the shareholders shall participate in the conduct of the business. We did advance that at paragraph 23 of the particulars of claim, and the judge found that was the relationship. If you go to page 10, and paragraph 28 in the judgment.
Yes, I mean, the judge held that there was a pattern of cooperation or participation in businesses based on mutual trust and confidence, and you're including this company with the other companies.
Yes, what he says is that in relation to each of their companies, each expected to participate in the management of their various ventures.
Yes.
And we rely on our written case at 5196. Paragraph 10. So 2 of the 3 categories were satisfied, and the third was satisfied in a practical manner because nobody would be likely to pay anything like a 50% of the value of OSL to Mr. Lau in consideration for his shares. And that, of course, is graphically illustrated by the fact that Beibu Gulf were not prepared to buy Mr. Lau's shares without Mr. Chu's shares as well. So that makes the point. A few points on Shelby. One needs to be careful how one uses the term incurably bad. If it's used to refer to those cases where the claimant does not have title to sue, for example, the assignment of copyright was defective, then that is of no application here because Mr. Lau was a member at the time the proceedings were commenced and plainly had little to bring and therefore had title to bring an application under the just and equitable ground. That application, at a minimum, plainly had a realistic prospect of success. It was not in any way abusive. If it was, then there should have been an application at the time to strike it out. If it were a proper application made at the time, then of course you can amend subsequently to add additional facts that have occurred subsequent to the issue of the proceedings, provided of course that sufficient notice is given and the court permits that to happen. In the absence of any application to strike out, the position at the commencement of the proceedings is ultimately irrelevant. You decide the case on the facts and matters and evidence that the court has permitted you to advance and adduce, regardless of whether they existed at the time the proceedings were commenced. And if we briefly looked at it, but I just want to go to one short paragraph in the judgment of Lord Justice Mance in the Meredith case at 6957. And it's the paragraph, if you've got it, at the top of the page, paragraph 23. We are, in my view, bound by Henry's case, which appears to me also to reflect the appropriate modern approach. Further, if and so far as it may be material, I do not regard the present case as one where, as at the date when Mr. Justice Moore-Bick made his order allowing an amendment, the original claim could be said to be incurably bad. The validity or otherwise of the first demand was a properly arguable point, which was only decided after a preliminary issue leading to a full argument. So he said, if the test of incurably bad is to be applied, then provided there's an arguable case, then it's not incurably bad. And the title to sue issue has been resolved in England so that even in an IP case where you do not have the title at the time, that does not make it incurably bad. And I'm afraid for this, all I've got is a passage in a Hong Kong case referring to an English case. So if we go to 6590, this is a decision, the Hong Kong case, and if you go down to paragraph 37, they quote there they refer there to a decision of Mr. Justice Blackburn in Finland, and they say he gave leave to amend a claim form in respect of an assignee whose assignment of the rights of action took effect a few hours after the claim form was issued, and the limitation period expired the following day. In 46, Mr. Justice Blackburn endorsed the modern practice of allowing an amendment, the effect of which is to make good a defect in the claimant's title to sue, even though the event relied on did not arise until after the proceedings were issued, so that in strict law, the claimant did not have a cause of action at the time he issued its process. I entirely accept it's not a particularly satisfactory way of me introducing that case by referring to a Hong Kong summary of it, but there it is, my lords. Just so that you'll obviously, I imagine, want to set out what the present position is in respect of a Shelby, and that's there, and you're able to look at that case. My learned friend continued to assert that there was no breakdown in the relationship at the time the proceedings were commenced. We've already dealt with that, and we've referred to their own defence where they said there was a breakdown. But let's look at what Mr. Chu was saying in other cases. If one goes to 1337, and we see this is the case of Re Smart Place, where proceedings were issued on the 24th of November 2014, and you see at paragraph 52, Mr. Chu has completely lost any trust and confidence in the probity and good faith on the part of Mr. Lau, who acts through the first respondent. And if you go to 1423, at paragraph 50, again to the same effect, Mr. Chu has completely lost any trust and confidence in the probity and good faith on the part of Mr. Lau, who acts through the first respondent, etc. That was the 1st of December 2014. In relation to the subject matter limitation, we've already made detailed submissions in our written case and in my opening. And again, my learned friend keeps relying on effectively the Locke and John Blackwood case and the Court of Appeal in Ocean Sino, and that gives no support at all because these weren't deadlock cases. And my learned friend said that union zone wasn't referred to by the judge. It was. It's referred to at paragraph 13. Sorry, paragraph 13 at page 5. I'm not going to take you to it. My learned friend refers to various matters. So we say the judge's analysis of the position up to the start of the proceedings can't be faulted. There was plainly a deadlock. What my learned friend does is to refer to matters that were raised subsequent. Sorry, I was making these notes as my learned friend was making the submissions. Let me just check that I've got the right my right reference here. Yes, this is in terms of responsibility and the issue of sort of sole cause. If we go to page 6, paragraph 16, as I've always accepted, the applicant does not have to be purer than driven snow. And then the judge refers to that it's necessary to establish exclusivity or substantiality. In fact, as we point out in the written case, the reference to substantially in R.A. Noble and Sons is in fact a reference to the respondent, not the applicant. And the test is the sole cause of the breakdown, as set out in Lord Cross's judgment and as endorsed by the Court of Appeal, the English Court of Appeal's decision in Paramount Powders. I entirely accept that when we made the submissions to the judge, that's our mistake. That's how we submitted it. But nevertheless, it's even more in our favour because the judge asked himself whether Mr. Lau had exclusively or substantially caused the breakdown. So that's a point actually in our favour because he finds that he didn't. And then if we go to page 33, paragraph 94. The judge expressly found that both sides bear a measure of responsibility for the state of affairs that existed between them. So it's no good, as it were, taking an island-hopping approach to various documents and trying to make out that that didn't put Mr. Lau in the best of lights. The judge finds that they both bore a measure of responsibility, but for the purpose of deadlock, that doesn't matter, and indeed that is largely inevitable in this sort of situation. If one party, as it were, does awful things to the other party, then the other party may well do awful things back. And it'll come on to the point that I'm going to touch on later, which is that what is important about the deadlock line of authorities is that you do not have to attribute fault. And I think that's the point that my Lady Arden makes. So, the judges, but of course what the judge does go on to say is, if I have to choose, and he doesn't have to choose. He doesn't have to choose, but if he had to choose, then he had little hesitation in finding Mr. Chu the more culpable.
My point was that in deadlock, you don't have to show impropriety, and that was why it was a shortcut, one of the reasons why.
My lady, I'm sorry if I missummarized my lady's point. That is how I understood it. And it'll come on to the alternative remedies, that if you've got a energy situation, you don't have to jump the higher hurdle of showing impropriety. And next, once you've decided there is a breakdown, which the judge did, then it's no good trying to blame things on one or the other afterwards and trying to show misconduct. If we could go to 5199. This is from our written case, and if you can go down to paragraph 22, this is from the judgment of the board in Vijonovic and Vijonovic. Now, in that case, it had been held by the lower courts that the petitioner had misconducted himself by diverting business away from the company after the breakdown in trust and confidence between the parties had already occurred, but a winding up order was nevertheless made. Lord Oliver, given the advice of the board, upheld the winding up order and rejected the clean hands argument, holding, after citing the passage from Lord Cross and Ibrahimi, what Mr. Thames seeks to do is to extract from this the reference to come into court with clean hands, as if it stood alone, and to suggest that since both Mr. Justice Henry and the Court of Appeal were of the view that the respondent had misconducted himself in relation to the diversion of business away from the company, that should have concluded the case against the making of a winding up order. The same submission was made to the Court of Appeal, who rightly rejected it. It's quite clear that Lord Cross was considering the position in which the petitioner's misconduct, and thus the relative uncleanliness of his hands, was causative of the breakdown in confidence on which the petition was based. And no analysis of the facts could that possibly apply here. The transaction concerned did not take place until 1986, long after all confidence between the parties had irretrievably gone, and it did not come to light until the trial. Whether or not the Court of Appeal was right to regard it as a consequence of the breakdown, it was clearly right in saying that it was not the cause of it, and in regarding it as being no bar to a winding up order if such an order was otherwise appropriate. So in there, they'd found that there'd been a breakdown, and subsequently, the applicant had actually gone and misappropriated, misdirected business afterwards. But the board said, well, that's not relevant. It wasn't actually causative of...
Lord Leggett wishes to ask a question.
Oh, I'm so sorry. Yes, please.
James, you may be coming to it anyway, but what I'm speaking for myself am more interested in than the generalities are your response in a nutshell to Mr. Hacker's key points, which I see at the first stage as being that there wasn't a breakdown within OSL because the two individuals were able to agree that the repayment of the loan would be dealt with within the Gulf company.
Yes, I am going to come on to that. I will do it now.
Yes, you only have about 8 minutes, I think, or 10 at most.
Yes, let me do that quickly. The reality is the breakdown had occurred. What Mr. Lau was attempting to do was to try to get his assets out of Beirut Gulf. And the fact that they can have an agreement to get rid of the joint venturer so that at least the vessels are one step nearer Mr. Lau. But what that can't be is some sort of, what you can't do is to take that as, well, we've come to this agreement, everything's now hunky-dory, we're all going to manage it together, happily ever after in PBM. And that's exactly what the judge goes through in detail. And if you look at the judgment, if we go to page 21, at paragraph 65, this is where the judge deals with it. And it's important to see his assessment of all this. He says a resolution of the directors of Beirut Gulf made at, this is the introduction, made at the 26th of November. So we then turn over to the paragraph 67 on page 22, where he says, after the delays and rescheduling above mentioned, a lengthy directors meeting of Beirut Gulf was finally held over the 15th to 16th of December. The proposed upshot, so far as relevant to these proceedings, was an agreement that the PBM loans would be utilised to repay loans to Credit Suisse due in respect of two operating shipping companies. The loans would then be treated as repaid, in part by satisfaction by the allocation of two vessels to Beirut Gulf, would be sold to PBM. The vessels owned by these companies had been purchased using 36 million of the loans, but now PBM would need to raise the necessary finance and to agree what would happen to the vessels. So this is only the first stage. What it is taking it out of the joint venture, so at least it's nearer. But there would need to be two further agreements. How do they raise the finance, and what's to happen once it comes to PBM? Because these two could never operate PBM together. They simply couldn't cooperate. And then what he says is, need to raise the finance, agree what would happen, should they be managed by PBM or be further allocated, allotted one to each of Mr. Lau and Mr. Chu. Any balance would be deposited into the escrow account. Though Mr. Chu thought PBM would end up paying, Mr. Lau thought otherwise. Then what happened was that at 68, the two vessels go to the PRC lot, but the two do not go to PBM. That did not happen, and it never happened. So even on Mr. Chu's interpretation of the agreement, the vessels never went to PBM. They always stayed at the Beirut Gulf level, which of course he hijacked and kept control of. And then going over the page to 23, as previously indicated, in return for the acquisition by Beirut Gulf Holding, the shareholders' loans would be set off against the purchase price. And then it would be necessary for PBM to raise the purchase price and agree how the two ships should be managed. And of course, they couldn't agree it, which is just demonstrates that nothing can be agreed at the PBM level. Yes, they might have agreed to get the ships down to the PBM level, but what would happen thereafter? Instead, and this is important, as revealed only in his fourth and last affidavit, Mr. Chu arranged by a series of complex transactions for the Credit Suisse secured loans to be replaced by secured finance by way of loan of some 18 million on convertible bonds issued to PBM as reflecting their interest. So what was happening at the same time as this was the lowest transaction. My learned friend sort of put a passage which Mr. Chu had said in cross-examination, where he said, oh, there was actually a bridging facility and this was only done later. Well, there was no evidence of that. He'd never said any of that in his affidavit evidence. And why, if there was a bridging facility, why was the demand being made at a later date for an agreement on the 28th of December? And it's actually in our agreed statement of facts and issues that this transaction happened on the 28th of December. So you know, you have to put the board meeting in the context of what was going on, which was the lowest transaction, which he kept hidden, and this was a PBM transaction as well, he kept hidden from Mr. Lau for 16 months until the trial. That itself proves there was deadlock. He couldn't put it to Mr. Lau. No doubt he didn't put it to Mr. Lau because he thought Mr. Lau wouldn't agree to it. That's the issue in the case. And then what the judge says at 71, all this was meant somehow to reflect the agreement or solution resolved upon at the December 2015-2016 meeting, but was completely different from what Mr. Lau had envisaged. All was done without Mr. Lau's true knowledge, true agreement, knowledge or consent. Despite being a director of and a shareholder of PBM, he was simply presented with a fated company. How PBM managed to enter into such a transaction in the absence of Mr. Lau's knowledge and consent was never explained. Moreover, it must have potentially, if not actually, altered the underlying value of PBM's rights and interests. So to just take, as my learned friend does, and you can go on here, but I have shorter time, to just take the board meeting, to take it in isolation, which of course is exactly what the other side want to do. They want to say, I can't rely on anything that happens after the presentation of the petition. You just can't do that. You have to take it in isolation. It is evidence, the strongest evidence of the breakdown and the incapability of these two to cooperate. Well, I didn't actually start until 25 to. Could I possibly go on 5 minutes, my lord?
Yes.
Thank you. Now, we, on the facts, we have set out 17 pages of our case in response to the facts put forward by Mr. Chu. Mr. Hacker didn't refer to any of that. The purpose of putting that forward was to show how his presentation of the facts is either wrong or a unfair selection. So I can't, as it were, do any more now, but I did expect Mr. Hacker to actually deal with what our points were. The reality is there is no answer to those points. Now, finally, the alternative remedies. The final issue on the first case is the issue the judge had to determine was whether, at the date he was handing down his judgment, these parties were going to be able to cooperate in the future. That was the decision he had to make. That is plainly a decision which is based not just on the documents, but the 4 days of hearing the witnesses before him. It is his assessment. If I dismiss this petition, are these two likely to be able to cooperate in the future? That's the date you have to ask that question. That was a decision for him, and it was obvious at that date they could not cooperate. At that date, Babu Gulf had been hijacked. The lowest transaction had been entered into. What it was, we never knew. Did it affect the value of PBM? What the position then was that any board, independent board of PBM, would investigate what the matters were and would, if appropriate, take proceedings. This board of PBM was incapable of making a decision as to whether it should sue Mr. Chu, basically. So that proves the case. Now, the alternative remedies, and can we just briefly look at, is this the originating application? Yeah, if we can go to, oh, sorry, I just need to go to the page 54. This is the originating application, and it sets out the grounds relied on. So it's, if we go over the page to 55, the grounds upon which we seek the order, the applicant is a 50% shareholder, etc. And then paragraph 2, there's been an irretrievable breakdown of trust and confidence as between applicant and Mr. Chu. As a consequence, the respondent is deadlocked at both director and shareholder level. But it's a bit of a smorgasbord of pleading here. And if one goes to the next page, no, it isn't in there. It's in the affidavit of Mr. Lau, where what he says is that Yes, that's paragraph 7. The actions of Mr. Chew are causing the applicant prejudice. Mr. Chew's actions, etc., etc. So when I submitted to the judge that there was power for a buyout, that is dependent on finding that there's been unfair prejudice. Because, of course, the matters that had subsequently introduced to the case were all alleging breach of duty. So if the judge found that there had been unfair prejudice within the relevant statutory provision, then the mere fact that there wasn't a formal unfair prejudice application would be a matter of form rather than substance. So that the judge would then, if he made those findings, have power to make the alternative orders under section 184I. But as we've set out in our written case, those appropriate orders included an order to appoint a liquidator. And what we've done is to go through those. And what we've said is that even if this had been framed as a minority shareholders petition, there was only one solution here for the reasons we've set out, which was to apply to appoint a liquidator. Deadlock is not coextensive with unfair prejudice. We've dealt with that briefly in 5129 of our case. At paragraph 1884, we refer there to Hawkes and Cuddy, and in the footnote we've got a similar point being made by the Singapore Court of Appeal in...
Mr. Jones, given the lack of time, I think you better just give the page references you want us to look at rather than develop your submission, because
yes.
you're within a minute of the end of time.
5129 is the page number, and the paragraph, we'll just read that page and then the footnote reference 48.
Sure.
But because the judge did not go on to find that there'd been unfair prejudice, and he didn't need to, because there's a lower hurdle, then that jurisdiction did not apply. But if it had, then the only order would have been a liquidation order. And finally, the point that my lady made, my lady referred to paragraph 100B. Could I also ask the board to just quickly go to page 33? I'm going to not make any more submissions, my lord. I just won't have time. Can I just deal with this? Page 33. Page... Yeah, page 34, paragraph 97. Could I just please ask you to go to that? What he said was, I do not consider that Mr. Lau is bound to embark on speculative and no doubt expensive litigation in seeking a shareholder remedy, whether in this jurisdiction under section 184I, the Business Companies Act, or the equivalent legislation in Hong Kong. Yes, what one has to do is a two-stage test. One, what were the alternative possible remedies? I accept theoretically unfair prejudice. Next question then was whether Mr. Lau was acting unreasonably in not seeking that remedy. And what the judge was saying is that he has, by implication, properly pursued a just and equitable remedy. It doesn't require impropriety, and he's not going to dismiss this petition simply because there is another remedy that he can now pursue in some other proceedings. Otherwise, I repeat all the points that I've made before. I'm sorry, my lord, I've gone, I think, at least 2 minutes over the 5 that you permitted me.
You have indeed, Mr. Jones.
I'm glad for the indulgence. Thank you.
Thank you very much. Well, it only remains for the board to thank counsel and also those who have assisted counsel in the presentation of these appeals. the matter will obviously take some time to be considered, and the board will take time so to do, and will humbly advise Her Majesty on the outcome of what should be the outcome of the appeal. Mr. Jones, you are muted.
Oh, somebody's unmuted me.
Yeah.
My Lord, could I just remind you that this has been arranged as an expedited hearing? And the fact is, we've not got any liquidators in place, which, if you're going to be with me, we urgently need them in place. I've been told, in order for the next hearing, it should be sometime the end of October.
Mr. Jones, I'm aware it's an expedited hearing. I was on the panel that expedited the hearing. Thank you very much. The board will now adjourn.